do so. From the onset, I will refer you to Section 33 of the Constitution, Act Number 6. Section 33 of the 1991 Constitution. Section 33, in fact, begins with the marginal note of functions of the Electoral Commission. It says, subject to the provision of this Constitution, the Electoral Commission shall be responsible for the conduct and supervision of the registration of voters for and of all public elections. And referenda. And for the purpose shall have power to make regulation by statutory instrument for the registration of voters, the conduct of presidential and parliamentary elections, or, I emphasize these other words, my lord, local government elections and referenda, and other matters connected with it, including regulations of voters or proxy. I'll come back to the issue of local government elections. That's why I'm emphasizing it. Because it's part of the plaintiff's case, basically questioning the legality of the regulation for local government elections. From these powers of the Electoral Commission, it's very clear that everything that has to do with elections are under the purview of the second respondent. This presupposes that the Electoral Commission has a specialized, exclusive information. The Electoral Commission has specialized, exclusive information at its disposal to determine the conduct of elections.
Specialized, exclusive,
and exclusive. Yes,
information.
Yeah, information. Yes, ma'am. Specialized and exclusive information to conduct public elections, whether it is in 2060 or 2040, so long as it is public elections. And at the point I am making, it is the Electoral Commission is the second respondent that can inform any other institution, be it the office of the president, parliament, or any institution, whether any specific act of conduct of election is possible or not. It is the Electoral Commission's privileged position to say what is possible for any elections based on the logistical possibilities at the point in time. No other institution can challenge that without contrary information. I hasten to say this because my landed senior, but the plaintiff have said the practicality and ability has been purported to give us excuse not to conduct elections by constituency elections. Because apart from the fact that what he said has not been supported by any fact, by anything, absolutely, or whatsoever, no other institution is in a position to provide what they call in intelligence service a bird's eye view of electoral processes than the second respondent. Look, I will go further to say that in the In order to underscore the point that made, I will refer you to sections 38, subsection 7 of the Constitution. And as it says, for the purposes of these sections, the number of inhabitants of Leone shall be ascertained by reference to the latest census of Leone, then pursuant of an act of parliament, or if no census has been in reference to it available. It says, what I wanted to refer to is that it says, in the opinion, is it 38.7? It says, in the opinion of the Electoral Commission. In the opinion. It did not say in the opinion of any other public institution or entity. It says in the opinion of the Electoral Commission. That I also want to bring to your attention that when I read this section, I had recourse to go back to the Constitution and count how many times the Constitution says in the opinion. It's not more than 5 times. The entire Constitution. Which means that the Constitution and the drafters realized that there will come a time when this specialized agency will have to decide based on this information that is reviewed. Based on what I have just said on section 37, I would also want to bring to your attention that there is an issue of discretion, which I want to introduce in this submission. The issue of discretion of public institution. When is it appropriate to challenge the discretion or not of a public entity?
Is discretion different from opinion?
That's what I said, discretion. The opinion, the exception introduced discretion in the opinion of the Electoral Commission.
Yeah.
You know, administrative law is very clear that there are little, or there is little opportunity to challenge the discretion of a public institution. Because in many instances, the public institution will have to take a decision that can only be informed by what they have. And it went further to say that in order to challenge the discretion of a public institution, that discretion must have violated certain tests that have been set up in case law. Certain tests. And I will list them for you and quickly try to explain that. That is actually the 7-part test. One is whether the public institution acted reasonably. Two, whether that public institution followed the correct or due procedure. 3, is whether the decision that has been taken is within the limits of that public institution.
Just the part.
Sorry.
Whether that public institution are following due process. Is that the second one?
Yes, sir. Due process. Correct in the due process.
Yeah.
3 is whether it is within the limits. How about the second? The second is whether the decision followed due process.
Whether it is within
The third one is whether it is within the limits of that public institution.
the limit or
Limits. 4, whether the decision or the discretion is rational and evidence-based.
whether
It is rational and evidence-based. whether the decision was published after it was taken. It was taken. Whether the decision was published. And so 7, whether the decision serves a proper purpose. Proper purpose. There is the 8th requirement, which is called the Sedley requirement. Sedley.
Whether the decision serves a
Proper purpose. Sedley. Yes. This is just Sedley who actually propounded, which means whether consultation took place when that decision was taken. You know, that's the 8th Sedley requirement, consultation.
whether proper
Consultation was done when this. You know, just quickly.
who are you referring to?
Beloved.
How many? I'm talking about authority here.
Oh, beloved. Okay, sorry. You know, this is founded on the basis of administrative law. But each one of these grants have their own supporting case law, which I will mention in brief. And beloved, there is the Hansberry rule. Okay. Beloved, I would refer you to a very leading administrative law text. The authors are Michael McMahon.
Michael
McMahon, M-C-M-A-H-O-N. Michael McMahon and Paul McMahon. Paul McMahon. Constitutional and administrative law. Yes. That's what I said. I said the leading administrative law textbook. Constitutional and Administrative Law, 15th edition. 15th edition. Because I will submit that the second respondent meets the requirements set out in the decision of the second respondent to conduct the elections by proportional representation of district block system meets almost all of these requirements. All of them. Possibly they acted reasonably based on the information they have that it's practically impossible. Reasonably. That it's practically impossible for them to conduct the binding delimitation based on the recent midterm census results. Sorry?
You are saying that they have acted reasonably.
Yes.
Which is objective point of view.
Yeah.
But you are saying that everything going on in the electoral commission, to me, you understand, when you say that, that would be our opinion. But it's not subjective. Objective and subjective.
Well, it's this subjective objective test in this instance. Because basically we cannot determine what they know.
Because you are talking about reasonability and subjectivity.
Yes, but the issue of reasonability is not just respect to an objective test. There is an objective test when the individual acting realizes that what I am doing is going to be reasonable at this point in time. Even though you are doing that from the subjective point of view.
Reasonability test.
Yes, but it's still an objective test.
So carry on.
The second issue is following due procedure. If you look at the press release which the Electoral Commission released, basically it's very clear press release shows that they meet the requirement of one, the self-test, and following due process based on the Constitution, based on sections 38 of the Constitution. The Electoral Commission has advised the President, the procedures that advise the President, that it is practically impossible to conduct elections by constituency. Therefore, we go by proportional representation. So the procedure is followed. And the law, again, clearly, it's within the law, within the limits of their powers to advise the President, and the President will make a proclamation, and they take directives from the President. Now, what informs that advice is the information that they have, that if they have undertaken boundary and voter registration, the timeline within which they could have done boundary delimitation will mean they will interfere with the 6-month time span that is required not to interfere with. Now let me give you back on this results and explain it. Yes, sir. Within the timeline in which they should not have interfered with the 6-month timeline that they should not have interfered with pursuant to the Public Elections Act will have been tampered with, which could have again, which could have led to the second respondent asking for the shift of the electoral date in order to respect sections 18 of the Public Elections Act. Sections 18 of the Public. If they had conducted boundary delimitation, would have interfered with the timeline, which would have led to them requesting for the election dates to be shifted beyond June. And we know what that will have caused, particularly in this toxic political dispensation where the Electoral Commission believe their law has been a major problem on issue. Asking for shift of elections from May to any other date will have been tolerated. And it will have, most importantly, will have violated the rules, will have violated the Constitution itself.
You said you want to make it called
May? June, sorry. Will have violated the Constitution itself. So the point is there was a willingness to do it, but the timeline was short. And so what I'm basically saying is there was sorry.
I think we're moving to the choice. I believe strengthening the law.
But there's no evidence of what you see. None of it before the court, whether in affidavit or in reference document. There's no evidence of this.
Without there, these issues which I am talking, which I am basically expanding in the statement.
What's true? That's the best thing because you're taking the case. Identifying values and requiring to.
Yeah, I think it's part of the evidence before you. It's in the statement of
Yes,
case.
when you are
It's very clear. I have not even come to those issues yet. I'm referencing them, basically explaining this 7-part test that I'm talking about,
Yes, you
which anchors on challenging the discretion of public institutions. That's just the first point which I'm adding. I'll come to these issues where I'll point to this evidence before you now. Let me just run through this. So it is within the reach. Again, the next factor is rational and evidence-based. Again, like I said, the Electoral Commission will present before you, and there's already evidence that the population density of Sierra Leone has shifted. It is in the statement of case, and it is in our statement of case, it is before the statistics document that is attached, that there was an excess of 57,000 votes were made for people already. And that is rational and evidence-based enough for the Electoral Commission to say, look, wait a minute, if we cannot conduct elections based on the recent census, then clearly we'll have to look for something else. It's evidence-based that we took the decision. On the third requirement, the Electoral Commission consulted with the President and the decision was taken. And most importantly, this was done in the best of faith, good faith. We have to conduct elections. We cannot shift constitutional requirements. We can't shift the date. The only way to meet this constitutional requirement is to have elections conducted by the state process. Good faith. It's nothing as good as that. Immediately after the decision was taken, it was published. There's a press release which the plaintiffs themselves have executed for your reference. I will move on to the next issues. I want to talk about the issue of population shift. The population density. And the plaintiffs mentioned that many times. In our statement of case, we have pointed out to this court that the population statistics that was published by Statistics Bureau, the institution responsible for conducting housing and population census, indicates that there was a significant increase in the population in Sierra Leone. There is a significant increase in the population in Sierra Leone after the midterm census. And because if there is a significant shift or increase in population, which triggers the need for bandwidth limitation. Triggers the need for bandwidth limitation. On this basis, I will refer you to section 38, subsection 4. Where the second respondent is empowered to undertake bandwidth limitations. Lord, I will read from it. It says, the The Electoral Commission shall review the division of Sierra Leone into constituencies at intervals of not less than 5 and not more than 7 years, and may alter the constituency in accordance with the provision of this section to such extent as it may consider desirable in light of the review. It is very clear that after statistics, Sierra Leone has published the population, the statistics. It is the mandate of the second respondent to now undertake boundary delimitation. And at this point, I want to point out that if the second respondent cannot do boundary delimitation, it cannot rely on statistics, because the only statistics that they should rely on is the recent population census statistics that is published. You can't skip that and go back. Now, so the problem is, and you know, this is pursuant to section 38(7). It says, for the purposes of this section, the number of inhabitants of Sierra Leone shall be ascertained by reference to the latest statistics of the population of Sierra Leone. The latest statistics, the latest census of the population of Sierra Leone, held in pursuant of an act of parliament. You know, it's already a latest census. If you cannot use that, you can go to 2015. It's not the latest. Now, because you cannot use it, it triggers the need to advise the president to conduct elections by this process. We can no longer talk about correct constituencies. And this is where the issue of democracy comes in.
Is this the first time that it's happening?
No, this is not the first time. In terms of conducting elections by this is Brussels. No, we are having census and elections. In fact, there is a history of it which we enumerated in our statement of case. Let's not get too different. You know, even before, there has been a sequence of census, boundary delimitations, elections. Census, boundary delimitations, and elections. You know, this is something that we have pointed out for your attention in paragraph 11 of our statement of case. Census in 2004, and there was an alteration of boundary delimitation in 2006. There was a second population census in 2015, and there was another boundary delimitation in 2017. And in fact, what that did in 2017 is to create more constituencies. And you know, I want you to take judicial notice of it. It was just 53,000 differentials in the numbers. It was only 53,000. In the statement of this one. Paragraph 11 there. You know, so now in 2022 you have 57,000 population difference, which eventually will trigger boundary delimitation. And if we are basing, if we want to base a projection based on the evidence of 2015, when there was 53,000 Lord, new constituencies were created. Ghana was divided into additional constituencies were added. I think about 20 of them. So now if you have 57,000 more population, more people, it means there will be a shift. If you conduct, if you, sorry, if you, sorry, yes. In 2015, the population increase was
112 to
132.
132.
Yes, because there were additional 20
That's
concerns.
just 53,000.
Yes, 53,000.
Now it's 7.
Now it's 57,000. So imagine what will happen.
So then you had all the districts
Yes,
and constituencies.
you can add one district, maybe another 5 districts, maybe. We don't know. But if NEC had, if the second respondent had gone into that, you would have a certainty. But so in terms of democracy, it will be undemocratic to use an old statistics to deprive people of a new constituency. That is where the question of democratic and undemocratic issues or tendencies come up. Do we now say we need those people who have popped up over the last 5 years because we want to please someone? Or do we follow the precedents that have been set to ensure that if there is a population increase, we do boundary delimitation? Or where it is not possible, beloved, we look for an alternative. And the only alternative we have is to fall back to section 38, 1A. If that's it, I'm sure my colleagues argue that sufficiently. But if the draft wanted 38, 1 God, to wrap up, you have removed. But it's still in the law. It's a ground law. If it makes provision for alternative, I listen to I always refer to him as my mentor. I have learned a lot from Dr. Abdullahi Conte. I was doing my PhD at that consultant. And I listened to him when he says that he doesn't think there is any other electoral process other than constituencies and that. There is no limitations. Electoral systems are decided based on the evidence available. That is why 38 1A came into effect. We cannot try to buy that to it.
Dr. Abdullah,
Yes, sir.
do you have any, or do you have any time frame?
I beg your pardon, I thought you were addressing me. We have my question as Salone.
Yeah. Do we have a time frame when that we conduct boundary decision this year?
So there should be voter registration and delimitation. The time frame which we have is all of these processes should not take place 6 months to elections. They should be before. Now, what really constrains the second respondent is the time for the publication of the census results, which came in September 2022. Milord, at that point in time, the president of Salone had acted legitimately based on the constitution to announce a date for the elections. It said that June will go to elections, which means the second respondent was now constrained by time to do voter registration, boundary delimitation before the 6 months timeline, which is January, which was impracticable. And that is a word that we use in our statement of case, impracticable and inability, which I think my mentor was really clear about, and he says we're looking for excuse. We're not. It was impractical to do all of it. And that's the only reason why we're here. And that's the case for the second respondent. We cannot conduct both boundary delimitation and voter registration before 6 months. We will violate our own Public Elections Act Section 18, and we will violate the International Protocol on ECOWAS Section 2 of the ECOWAS Treaty on Good Governance. It will make us look bad as if we're doing things outside of the law. So therefore, we consulted with the president and said it's impracticable. We will be unable to do this. That's why we're here. That's the case. And that's the explanation. And no one else can give a better explanation to as to why we did this. And I still recall the words of the question from Dr. Abdullahi. Why? And that is the answer to it. Why? It's impractical. Let me move on to the issue of local government. Not the plaintiffs have questioned the issue of local government. And I think when I started the law, I read sections 3 of the Constitution, and I emphasized the issue of local government. There has never been any special rules or provision as to how you conduct local government elections, save for in statutory instrument. From 2004, when local government elections were introduced in Sierra Leone, it has always been conducted based on regulation. And those regulations have been drafted by the second respondent. Below section 33, again, I will refer you to of the Constitution. It says that the second respondent has the power to make regulations by statutory instrument for the registration of voters, the conduct of parliamentary or presidential elections, or local government elections in this area. So what the second respondent has done is as soon as the government, the president of Sierra Leone, as soon as the president was advised on the impracticability of holding constituency elections and a declaration was made, they now drafted a regulation. They started working on regulations. It was the regulation for which there was an argument of the numbering and citations. But that regulation is very detailed. It talks about how you go about the calculation, what is population quota, and everything is embedded in that regulation. Because this is a new dispensation at this point in time. Introduced because of the exigency of not being able to conduct constituency elections. I will refer you to that regulation. I will refer you to the various tables, the schedules. Table A, B, C, Schedule 1 is Table A, B, C, and D, basically laying out the mathematics. Schedule 1, tables A, B, C, and D. Laying out the mathematics and formula under which these elections can be conducted. Therefore, the powers to do this regulation is derived from the Constitution. And it's clear in section 34. It's very clear that they have the power. Not anybody, not the local council, not the local government ministry, but the second respondents have the power to make statutory regulations for local government. So, even within that regulation and respecting the 6-month timeline, that is why this regulation was laid before Parliament and adopted. There is no question on the legitimacy or legality of these regulations. And below, I will refer you to sections 2, in part 2 of the regulation. It says, subject to section 33 of the Constitution, of the 1991 Constitution, local council elections shall be conducted by proportional representation system. Okay. The right, section 2 of the regulation 2, sorry. Regulation 2 of the statutory instrument, local council proportional representation system regulation. Sorry?
Regulation 2 of the statutory instrument.
16th November. It's supplement to the Salone Gazette. Because finally, I want to finally talk about the issue of the population. Sorry, I didn't hear that. Statutory attack also. It's statutory instrument number 15 of 2002. Sorry, I didn't hear that. No, I told you it's attached to 2022. Published on the 16th of November 2022. Now, let me refer you to section 38.3. I want to emphasize it because 38 says the boundaries of each constituency shall be such that the number of inhabitants thereof is as nearly equal to the population quota as is reasonably practical. We're saying here that if we cannot use the recent statistics, which is the midterm census of population and housing census of 2022, we cannot fulfill the requirement in section 38.3. Again, I have referenced the 57,000 increase in population, and there is no way, by no means, the constituency election will do justice to population in certain areas. In conclusion, we have provided to this court the clear explanation which is in our statement of this. Yes, ma'am.
Sir, yeah. You made reference to section 38. What's your submission?
Section 38.
Sub 3.
Yes, sir. Yes. Yeah, it's a proviso there. Only. Section 38.3 has a proviso which says that.
You have a proviso there. So
Yeah.
what is your submission?
That provided that the number of inhabitants of such constituency may be greater or lesser than the population quota in order to take account of means of communication. This is mainly about logistical issues and distributions of what it calls different communities. Basically, it's saying that the inhabitants of that population cannot be greater or higher or lesser. And we can't determine that. We can't determine that until there is a proper agreed boundary delimitation. If that did not take place because of the impracticability of doing it, then 38.3 and that proviso go out of the way and will be a constitutional to act on. And for us as a second respondent, we cannot act contrary to the Constitution. Because we have provided to this court reasons as to why the second respondent advised the president of Sierra Leone to invoke section 38(1)(a) constitutional amendment, 2002, for elections to be held by district process. We have also explained and provided administrative legal basis and administrative law basis as to why the second respondent's decision to advise the president is based on evidence available exclusively to it and follows all the requirements set out by law. We have argued that to run the next election by constituency basis we have argued that to run the June 2023 elections by constituency basis will be most undemocratic, as it will exclude a lot of people who have been captured by the recent census. We have explained that sections 33 of the Constitution gives the second respondent the powers and authority to make regulations for local council elections. Finally, we have also discussed in detail below that the discretion of second respondent to advise the president emanated from the impracticability, let me use the same term, impracticability and inability to be able to conduct voter registration and boundary delimitation before election time.
You said that.
I'm summarizing it. I'm just summarizing it for your ease of reference. Except if you want me to address you on any of the issues below. We believe that this case has no merit. It should not waste the court's time and delay the well on track constitutional and democratic process of voting the next representatives of Sierra Leone into office. I submit and I crave indulgence to dismiss this case if possible. I have always said this in the Springbok, I am the legal consultant to the second respondent. Every time I have a case of this nature come to court, I say to them, I no longer work for the government of Sierra Leone for free. And they understand that. The costs that they pay for us doing this instead. And the Lord, if you agree with me, I ask that the cost
Very well. Tells you that 5 years after the last thing.
about
It is known to the Electoral Commission and it has been known to them since 2015.
Yes.
You have to run an election 5 years after.
Yes.
The SPV results are announced.
Yes.
Or the Electoral Parliament was next.
yes.
So why is it that
No, the situations that will trigger our actions are outside of our purview. Now, we are not conducting census. We don't determine how they carry it out. No, sorry,
you cannot make a request saying, you know we have to announce elections in 5 years' time.
Yeah.
Can you do something about
we
it?
can do that, but we have no powers imposing how they do their work. Independent body. But the point is, sorry, once the statistics say publish a result, we are required by law to act based on it. That's the point. It's outside our purview. We know this date. We knew this date will come. We're working towards having it done. And then, there is census. We have to come back to census and say, what do you mean? There's 57,000 people that have to be captured. Can we genuinely do boundary delimitation within this timeline? Milo? That's the answer to it. Thank you.
Thank you, respondents. Mr. Kawa. I know that you raised one or two issues which are coming now. For instance, the administrative aspect. So I will give an opportunity to Dr. Abdullahi Conte to reply to that, just to that. The aspect about the administrative law and
Lord Chief Justice, thank you for that burden to be borne by my colleague, Mr. Joseph. If there's anything to reply to, I only want to say
that was put forward to give an opportunity to him to reply.
let me just say, if there ever is a case of public interest litigation, this case is par excellence the candidate. It means second place to nobody. It is a public interest litigation that the plaintiffs have come to court to explain the electoral system and the laws of this country based on the jurisdiction, interpretative original jurisdiction which is conferred exclusively on this court. And secondly, to say, my Lord, maybe we'll give the necessary administrative direction. We belittle the weight or importance of cases when a case is filed in the registry, we mark it miscellaneous application. In most other jurisdictions, it is constitutional case number this, number that, not miscellaneous application. This is not a miscellaneous application. It speaks directly to the construction.
The point is taken.
After give the necessary administrative direction. Thank you. My learned colleague here would like necessary.
With the kind leave of my learned senior, let me start by expressing my position on the evidence question with regards to the attachments. Below, we have struggled through this exercise because council have made submissions of facts before the court. I'm saying that we have the commissioner of the Electoral Commission, who is the second defendant, who is in a better position to state those facts. I mean, Lord, if you look at Rule 92.2, the statement of the defense case shall set forth the facts and particulars. The facts and particulars. It is not counsel that will set forth the facts. It is not counsel. My understanding of facts, it is that this is information that is within the primary knowledge of the deponent. It is not for counsel on the other side to tell us about population shifts, statistics, population increasing or decreasing, and all those other issues of facts which are common to the knowledge of the second defendant. I mean, look, this is the position that I have with that. It shields the second defendant from coming to the witness stand and then we scrutinize him on that information. So, my Lord, if we are going according to the information of learned counsel who has made all the depositions of facts, may it please this court that will invite the commission and cross-examine him on those facts. Because that is the purpose of the law, and that is the purpose of section 92.2. Moving forward, your mind let me know that, but I will come to that later and follow your direction on the issues of the Wednesday submissions. That is an administrative law component. Below the Wednesday submissions are a derailment of the facts of our case. A derailment of understanding of the facts of our case. We are not inquiring into the discretionary exercise of that decision of the second defendant. Not at all. So the excursion into the Wednesday submissions of the 8-man tests is a point of discovery, comfortable only to the plaintiff, to the second defendant. We are not interested in that. But should you be minded for me to address those issues, you know what I mean? I will take the one that is the decision within the remit. The decision within the remit. It is a submission that the remit of the second defendant is to supervise and conduct elections. That is the remit. Two-limb remit, period. To supervise and conduct elections. It is a submission, you know, that there is nowhere either in the Constitution or in the regulations where it says that they have power to change the mode of elections. I mean, I would draw your attention to the Public Elections Act itself.
Good morning, sir.
Section 16. Section 16, you know, tells us what is the component of conduct of elections. You know, nowhere in 68 does it say you change elections or the mode. Nowhere.
Have you once changed the mode of elections?
Yes, you know. If you look at the statutory instrument, they said pursuant to section 33, they are now moving away from
They are making regulations. That is regulations. 33 is saying you can make regulations with elections. So far as mode, 38A, sub 1, that deals with mode. And that's the legislation.
Yes, beloved. It is our submission also that you cannot make those changes by regulation. It has to be by primary legislation. So that is the case that we have.
Primary legislation is the Constitution.
The primary legislation is the Constitution and any other act of parliament. You don't change a mode of election by a statutory instrument. I mean, the worst thing that happened is, if I may just address the issue of this statutory instrument for once and for all. You know, in our experience as councils, we time at the bar. When you look at the statutory instrument on its face, it tells you it's a statutory instrument.
Sorry, may I object? The plaintiffs have presented a case. What we have is a single case of the issues which he is raising, and we also be bound to ask that we give issues to reply to it, and then we go on around the circle. The issues which you raised, which you allow them to speak on, were the introduction of administrative law and a practice. And that's where we should see. They argue the issue of local government.
They talk about limits. Still within the limits that you're saying.
Yes, my Lord, I'm within the remits.
No, he's opening up a whole new argument.
It's still within the limits. Allow me, please.
Allow it also.
You know, he raised it up as a start test decision within the remits. It is my argument that they acted outside of their remit. And if I move forward, for him not to be bothered by that, I'll take the other one. Good faith. It is a submission that the second defendant has not acted in good faith. These are my reasons. The Lord, it is part of the exhibits for the plaintiff's case that we wrote to the second defendant several letters requesting information regarding this directive, to which no response was given. And today, as we stand here, nothing in this court has a copy of the directive that was given. Is that good faith? Transparency is beautiful if you have nothing to add. The moment you decide to hide something, it purports malafidis.
How would you relate what you have said to
Section 53 is another interesting.
What you have said, I've read the letter, and read the letter. And relate that to section 53 of the Constitution.
Do you want me to go into section 53? Senior counsel has identified something here. They may not have the 53 is clear. We've argued.
No. What was the purpose? Look at the content of the letter. I've read it. Look at the content of the letter which you exhibited in your document. The letter you wrote to the secretary.
Yes, the secretary to the
Look at
president.
it, and how would you relate the same to section 53?
Miller, I can only relate it that section 6.
So don't look at the letter.
I know it, I wrote the letter.
Now, what is the letter?
I wrote the letter.
You don't want the letter, but we
Yes.
With the last part now.
No, let me find it.
I don't want to calm you down.
Yes. Yes, Miller. You want me to read it publicly? And remember, publicly, Miller? Yes. Yes. The letter is written to the secretary to the president. The title is Presidential Directive to basis.
Sorry, sir. I am lost as to what Mr. Kamara is reading. Is it the letter that they wrote to the second respondent?
Yes.
Look, it's not different, sir.
It is the letter to the president.
No, there's one letter to the president. There's no letter to the president. He sent it to the president. Yeah,
That's the letter I'm reading.
there's no letter to the yeah, but there's no letter to the second defendant. We want to, it's different from the letter to the second defendant. If there is a letter to the second defendant, it's not different.
We accept that. But then he's asking the question, how would he relate what he's saying, like this letter, to section 53, which says that you cannot inquire? That's his question. So allow it.
Thank you,
He's
Miller.
talking about faith. Yes.
Thank you. The title is Presidential Directive to conduct June 2023 election on the basis of district block and proportional representation. We write in respect of the above caption and to formally request a copy of the Presidential Directive issued to the Chairman of the Electoral Commission to conduct June 2023 election on the basis of the district block proportional representation system. You may recall that the Chairman of the Electoral Commission in a press statement dated 21st October 2022 confirmed that a consultative meeting was held with His Excellency the President, retired Brigadier Dr. Julius Madabio, to update him on progress relating to the boundary delimitation exercise. Subsequently, on the 20th of October 2022, the Commission reportedly received correspondence from His Excellency the President in which the Electoral Commission was directed to use the district block and proportional representation to conduct the June 2023 elections. Within the context of the multi-elections will conduct the use of the PI system. It is our view, and we so hold, that on the true and proper construction of Section 38 of the Constitution of the Republic of Cyprus and Section 38A of the Constitutional Amendment, a directive issued by His Excellency Brigadier Dr. Julius Madabio, President of the Republic of Cyprus, violates, offends, and contravenes the said provisions when done without the condition precedent to which mere constituencies have not been established. Please be informed that we intend to seek a constitutional interpretation and enforcement of the Constitution before the Supreme Court of Cyprus, pursuant to Section 124 and 127 except. In light of the above, gratefully if you could kindly furnish us with a copy of the said presidential directive. We had written a similar request to the Chairman of the Electoral Commission 3 weeks ago, but our request was met with a deafening silence from the graveside. Meanwhile, it is always the needful will be done. And as always, it accepts the assurances of my esteemed guides. So coming to section 50, nothing has affected this content of the letter. As far as this letter goes, we talk about the intention to challenge the directive of the president that it has gone beyond the powers. And not about how they got you to read, not about the how. I hope that settles your query. So, my Lord, on the good faith, I will settle for that. That the second defendant has not shown evidence of good faith. Firstly, he was silent. Secondly, he only informed this country and the entire world about the PR system through Twitter. Through a Twitter information.
Was he acting as Salone?
Sorry, my Lord?
Was he acting as Salone?
No, my Lord. It wasn't. It wasn't.
If somebody is acting within the law, would you say that person is acting in bad faith?
You know, you can't, depending on the circumstances. You can act within the law in good faith, you can act within the law in bad faith. That is, how do you exercise the displeasure? Even in the exercise of your
How
displeasure.
do you prove it?
You know, when
You
that is
should
what,
come with things that will prove it. Who has asked for school?
well, you know, that is what I'm coming into. That is the fact I'm firstly expressing. That in the circumstantial position of the second defendant, it is clear that you have no intention of communicating to the public, especially when counsel has written to you. Please let us see the directive. No, we wrote to the secretary, to the president, not forward, and not to date as we stand here. No one has seen that directive if it's ever in existence. So, my Lord, I'll come to the next one.
Before that, I will invite you to look at. Said that information are within the exclusive confines. How would you react to that?
The exclusive
Information is within specialized exclusive information.
Thank you, my Lord. That is a very good point. It is within their peculiar knowledge. Let the public know what is that knowledge and what is the basis of that knowledge. And if you look at the provisions of that, it talks about consultation. Consultation. So whether consultation was done, we have not inquired into it. What we say.
What about
President acted beyond the
3211?
law.
What about 3211, which grants the Electoral Commission and electoral independence?
3211 of the Constitution. You know, it grants the Electoral Commission independence, understandable. That is functional independence. It is functional independence, but it stops at that. They owe a duty to the general public and the citizenry.
If they don't do that, can you dictate to them that you must do it the way you want it to be done?
No, my Lord, it's different. While you have the duty and obligation under the law, you have to comply. While in the absence of any duty, your discretion can prevail. The question and issue here is on the part of the second defendant to let the public know what the issues are and what is its impracticability. I mean, I'll come to the impracticability. The learned Justice Brahma has posed the most significant question with regards to that. They had 5 years since 2018. Since 2018, they knew the elections would be held. They did nothing. And they were waiting to say it is 6 months to the elections. And it is not excuse me, Lord, to suggest that the census has to be undertaken beforehand. There is an elections management body to which they are all parties. They belong to the elections management body and they've been meeting since 2018. And they work together in tandem and in team.
How do you relate that information with the fact that less than 5 years and not more than 7 years? If you take the less than 5 years, they are only fitting in. Less than 5 years from 2017 means it goes as far as 2022.
Yes.
So they could not have done it before that.
Yes. And so therefore, there is a provision under the Constitution. You go by the information that is available. You go by the information that is available. That's it, I think. You go by the information that is available. If you cannot go by the information that is now before you, that is given the census, You go by the election, by the information before you. And council mentioned that it is only them, the electoral commission, the opinion that will suffice in that circumstance. So yes, they're not bound to go by this midterm census. They're not bound. If they're dissatisfied, I mean, let me just inform you any testing component in that. This is what the second defendant has to say. That they are going to conduct the PR election using both 2015 and 2021 census report. How convoluted it is. And give the aggregate. So you know, they're the same people.
Sorry, may I object? May I object to that? Mr. Kumar is making reference to something that is not voice. I mean, what is the voice where we as a defendant can say we're using any other document other than the 2022 midterm census? Now we should restrict ourselves to what is up before this court, what they have presented, and all what we have presented to make this submission. I mean, you know, that is nothing. I urge you, this court, to disregard that statement and the colleague is basically restricting itself to what is being proposed.
I'm trying to answer. Thank you. I speak from the bar. And I challenge you to deny that fact. That they did not state that in the press statement. Recently, it just happened that when I'm speaking from the bar, I did not expect them to deny that. I mean, Lord, this is what I have my phone. I can
Sorry, Lord, please,
Let us speak from the bar, but they speak according to their belief.
Lord, if Mr.
I think their belief is a lie.
I will leave the court.
I want to cross-examine you on these things that you speak on the bar.
Lord, this is brought in the conundrum that we talk about when we entertain evidence outside of an affidavit. And it was deliberate that I brought that in. But all we said, these tests that are largely addressed in the administrative law context.
You raised this issue about evidence outside. You have all the opportunities to make the necessary applications, but we are only raising it now. We are not entitled. We don't feel that we want to entertain it.
We know that the issue of this list of evidence and there is a certain point in time, and it's not a preliminary objection. It's not a preliminary objection for which we have an obligation to disclose before that. We are now before the court, and we have raised the issue that when you depose to facts, they have to be the primary information of the deponent. And that is nothing but hearsay documentation.
Let me ask you one straight question.
Ask me more, please.
He mentioned something about elections, about the 6 months.
Yes. Yes.
You talk about good faith. If they are acted for saying elections, the date of the elections will have to be changed.
Yes.
And that again will be in contravention of the Constitution. It means the president's term of office and all that things might just change. And people may go beyond. Isn't that good faith?
My Lord, that is not before this court. It's been for him himself as a person. It's not before this court. It is an opinion that he has expressed. So, my Lord, again, this is the danger when we take positions that are not evident before the court. He was making in his statement of case, he raised an hypothetical case. He raised an hypothetical case that you have raised. I mean, look, it is our position that they got themselves into that conundrum. And it's deliberate. And that is what my valet senior said. Yes, my Lord. I recall very well.
So now you understand the importance of the 5-year application.
That is it. You know, you recall that I went on that to report my document.
Oh, sorry, you did not appear for the
Council.
I think
It's Farmer and Usman Kalu. So, my Lord, you can see where I'm coming from. Yes, why I'm sensitive about this issue from experience. So, my Lord, we're coming back to the argument. Because yes, I was addressing the issue of the statutory instruments. Would you want to hear me on that? The face of the title, the face of the document is where you see the title. And that will be about who was argument.
I don't want to go into that.
You don't need to go into that.
I did not give you
The latitude to get into that one.
that's what we have to do.
Yes. And he spoke also about the issue of the obligations of the second offender. That when you look at the Public Elections Act, he's the only person that has to draft those regulations. It's not very important. You know, there is a Local Government Act, 2004, 2014. There are all those provisions support. Nothing to do with the Electoral Commission. Nothing to do with the Electoral Commission. So this purported glamorization of the office of the Electoral Commissioner is incorrect. And in fact, it is this glamorization that has resulted in the usurpation of the functions. We cannot give it to him under the law. So we know finally on the point of the mode of elections. Look at section 171 of the Public Elections Act as well. That is one that we can make regulations. The Electoral Commission may, by statutory instrument, make regulations for giving electoral office. Make regulations. But when you want to change the mode of elections, it has to be primary legislation. And even if you want to do anything that affects the amendment of the Constitution, it has to be by constitutional amendment, not statutory instrument. Constitutional instrument. Below that, draw attention to section 171
This is the issue.
Yes.
That's it's one page.
Yes.
Units on the statute.
Yes.
And it is primary legislation.
Yes. Thank you. So it stops there. So if you have to comply with anything, it has to be that 818. Yes, it's sort of, so going forward to statutory instruments. Yes.
Section 73, it says statutory regulations, statutory instruments, because at that particular point in time, we never had the 1999 Act, which spoke about constitutional instruments. The effect about constitutional instruments at that particular time, 1991, it was only the constitutional instruments or whatever you refer to as statutory instruments. That's the reason.
And even when you are using powers derivative from the Constitution, like in 33, section 33, it has to be by constitutional instrument. It cannot be by statutory instrument.
By the 1999 Act, but it's still there.
But if you look at the new statute,
So I cannot say it is wrong. Can we?
no, that is my position, that it is wrong and absolutely wrong. Absolutely wrong.
What he's saying is it should be done by primary legislation, not by subsidiary legislation. I think that's it.
That's the next point. Not by subsidiary legislation. So, you know, having said that, it is clear that the statutory instruments, like we invoke in this court, to rule that they are invalid. They are invalid. They cannot stand. They cannot stand. They cannot stand in the face of the law. And you know, I see you restrain me. Not to address all the issues which the public might have. And just one question, you know, that one point you raised that question, if I may assist.
Pero tenemos
I don't think you know what I was about.
Yeah, but now administrative law analyst. Can you finish with that? You can't go into depression. I have that clearance.
So I take it that no more comments.
Lord, I wouldn't make any more comments. Saying that you don't want me to volunteer in areas that we are sensitive. Or be that as it may, I'm available. Should you by any chance want to invite me to comment? By law for gratuitous.
I'll remind you about 2017.
May not leave that word.
And
You and I know the experience we have.
the position.
And the position I took. Very familiar with it. You and I know how to
Apart from the documents you submitted,
Yes, we know.
are there any other documents that you want also have?
You know, we find supplemental case authorities. I think that is already with you. Beyond that, my very senior advocate information was with a copy of his argument of the justice.
Are there any objection to that?
Yes, my lord, I think you ruled on that issue already. The submissions were made. This will be like almost the whole new argument in details of this law.
Okay.
Those who don't have access to that now. Because the only other thing I want to mention, I have mentioned the administrative law authorities, which I also want to personally do, where they start test.
So you are not submitted.
That's why it's
You require to
it was a test.
No, sir, I'm not like that.
I'm like that?
You're not like that.
Like that.
You.
Now, sorry. No, I didn't go to one case. It was my mentor who mentioned it. I mentioned the paper test in administrative law. Sorry. And I quoted the book we tested. Resources. We tested, yes, sir. I quoted verbatim more money. I don't recall that often. So you have possibly pages. In the pages, relevant pages. Yeah, I can write the pages from my lab. I wanted to copy the relevant part of the thing with it. I will pass to the dates. Yes, for each of them. Thank you.
Well, I want to thank you, all sides, for the cooperation. You want to say something?
No, you cannot be addressing us and I'm sitting down. So one of us has to stand to receive your information.
I want to commend both sides, or all sides, for cooperation. We are at the end of the hearing. This is the first part. The proceedings. This is the hearing part. Now it's left with us on the bench to react to your submissions, and I will at this point say that we are going to adjourn. Judgment is reserved, notices to be sent. We'll make sure we call you out.
On behalf of my clients, express